Picture this, you are unwell, and when you exhibit a key symptom of your illness, instead of being taken to hospital, you're taken to prison because that is what the law stipulates. That has been the reality in Kenya in as far as suicide or attempted suicide goes. But today, a historic ruling has restored humanity and dignity to the country's legal fabric, and more importantly, to people battling suicidal thoughts and mental illness at large. The High Court has declared that the law which terms attempted suicide as a crime is unconstitutional. For context, a section of the law in question is a section 226 of the Penal Code and stipulates that, quote, any person who attempts to kill himself is guilty of a misdemeanor. Justice Lawrence Mugambi, in his judgment, declared that section 226 of the Penal Code is unconstitutional for violating articles 28, 27, 28 and 43 of the Constitution. Justice Mugambi said that part of the Penal Code offends Article 27 of the Constitution by criminalizing a mental health issue, thereby endorsing discrimination on the basis of health, which is unconstitutional. It continues to point out that it indignifies and disgraces victims of suicide ideation in the eyes of the community for actions that are beyond their mental control, which is a violation of Article 28. Further, the court holds the existence of Section 226 exposes the survivors of suicide and potential victims with suicide ideation to possible reprisals, thereby eroding the right to have the highest attainable standard of health envisaged in Article 43(1) of the Constitution. The Kenya National Commission on Human Rights has welcomed the landmark ruling in the case, which was whose co-petitioner alongside the Kenya Psychiatric Association and Charity Muturi, a mental health champion who died in early November. The Commission paid tribute to her, saying, though she passed on before witnessing this historic ruling, Charity will forever be remembered for her strong advocacy for accessible mental health services in Kenya.